at present still how unjust the system is. These are merchants who have been victimized once because they were victims of identity theft, no fault of their own, and then they're being victimized a second time by being on a 5-year prohibition list from processing.
Yeah, you didn't do anything, but we're going to punish you anyway.
And these are people trying to run a business to support their family.
Yeah.
This is the world we live in. This is, unfortunately, the stuff, which is why Bryce was saying, we want policy change. This has to change over time. I say all the time, Bryce, this is killing small businesses in America.
Absolutely.
Welcome to the Payments Experts Podcast, a podcast of Global Legal Law Firm. We hope you enjoy this episode.
Match list, as you've said many times on this podcast, Bryce, I'm not going to do the acronym, but if you are on the match list, one, it's very detrimental to your business because it basically means you can't obtain credit card processing for your business. In other words, you can't take credit card payments, which, as we know, in 2025, if you can't take credit card payments, good luck running a business.
Yeah, at this point, it's like, you know, you have the right to life, liberty, pursuit of happiness, and the ability to take credit cards, because it's like, you know, as I think I've said before on several of these podcasts, that like once COVID came down and once everybody was locked in their homes, cash and checks just ceased to exist. And in fact, now I go to places all the time and they're completely cashless.
Right.
So if you don't have the ability to take a credit card, that's just not, you're not going to have the ability to make a living.
Exactly.
And so I would almost like, make it akin to a right now, because, you know, MasterCard and Visa, however they've been able to do it, have just kind of leveraged the fact that they're now the only game in town, and the unchecked power that allows them is just ripe to be abused. And I think it's being abused all the time.
A lot.
And these, you know, how these codes and violations are implemented, I think is just direct evidence of that.
100%. We've done, you know, this firm, Bryce, as you know, has been around since 2008. You know, we're going on 20 years now. This firm has done match list work that whole time, but really the program exploded after COVID, and which is when you got involved. And I mean, it's literally exponentially the number of merchants who are ending up on match list because the net is so wide now. Mm-hmm. And the number of people who flooded to online payments because of COVID, it's just seen, you know, it's obviously been great business for us. But to reiterate what you were saying, we love what we do because we're fighting for that little guy, right? You've got your average mom and pop merchant just trying to make a living. You know, they're not colluding. They're not, money, laundering. They're not doing these types of things. And yet they're finding themselves placed on this blacklist, sometimes with things that say money laundering or, transaction laundering. That sounds criminal. And so it's very scary for a lot of these businesses. Can we maybe, Bryce, start there? Can we start with transaction laundering, that reason code? What is transaction laundering for our listeners?
Well, transaction laundering, according to the MasterCard rules, is the merchant was engaged in a laundering activity, whatever that means. Laundering means that a merchant presented to its acquirer transaction records that were not valid transactions for sale of goods between the merchant and a bona fide cardholder. Now, what that means in English is that they suspect you of allowing someone else to process payments for the sale of their product, which usually hasn't been approved by the processor, through your account. And that's going to get you nailed every time. And I think right at the outset, the most important thing that a merchant needs to remember is that you got to run everything by the processor beforehand. You cannot make any assumptions about anything. The cards are definitely stacked against you. There's an entire hierarchy of people and institutions that are there to trip you up. And so it's always best to run it by the processor, who can then run it by the bank, who's the acquirer in this instance, to make sure it's okay. Because almost every time that we get these kinds of cases, it's just because the merchant elected to make a move without running it by the processor.
Right.
And, as I've said before, like the processor and the banks are extremely risk averse. And so that trickles down to the processors who work for the bank. So if they even get a sniff that something is happening that may hurt their relationship with the card brands, they're just going to say, we got like thousands of merchants in our portfolio, and this is just one problematic merchant. Let's just, MasterCard will come in and be like, hey, can you investigate, this merchant for transaction laundering? And they'll say, well, we'll actually do you one better. We'll just terminate him and match him.
Yeah.
And then
we're good boys.
Problem solved.
Yep.
And then when you get a lawyer, we'll just ignore him. We'll just ignore you until you become so frustrated that you finally decide to pony up and sue us. Then we'll hire a litigation attorney who will be assigned to your case, who I can actually talk to. And then when I actually am able to reason with them, we usually are able to work it out. But I also have learned over my time, the years in this business, is that most of the banks are not allowed to even talk to us.
Right.
So it's kind of moved from, it started where we were writing letter after letter after letter to the point that we're just like, screw it, we're being ignored. Let's just put the pedal down on this. And
right.
And many times it's just, following the complaint, and then the attorney comes in and goes, "Oh, wait a minute.
Right.
We don't need to do that. Like what's the issue here?" And
it forces them to actually review the file.
Yeah.
Yep.
And it also institutes court mandated guidelines or deadlines for a response that they cannot get around.
Right. Otherwise, they'll kick the can down the road.
Oh,
we'll get to that, Bryce. 100%. Yeah. What I love, Bryce, and the listeners right now can hear it. Bryce takes this stuff very seriously. He's very passionate about it. And that's one reason why we're sitting here right now talking about this. Transaction laundering, the way I often describe it to our clients and potential clients, is you've got business A and you got business B, two separate entities. You've got processing for business A. If you run transactions for business B through business A, that's transaction laundering. Yeah. That's a problem. I spoke to a guy just yesterday, Bryce. He's now a client of ours. He didn't know any better. As you mentioned, these are not bad actors. They're not trying to launder anything. They often just don't know. He had a DBA. He didn't register the DBA with the processor, as you said. He didn't tell the agent when he onboarded. So he was running legitimate transactions because it is the same LLC, but the DBA was listed incorrectly. So when the processor or the bank saw a certain name associated with these transactions, they didn't take the time to look at the file and realize, no, it is the same LLC. This is one entity. They said, well, this name doesn't match the LLC, therefore it's transaction laundering. That merchant's now a match list, and you're going to have to fight to get him off the match list.
Yeah. Does business B sell a different product than business A?
Well, in this scenario, there is no business B. It's business A, but he didn't list the DBA.
And the DBA sells the exact same product as
Yes.
Yeah, you have to disclose that
right
to the processor before.
Right.
You cannot make any assumptions. And again, like the majority of the time, when you sign up and are approved by a bank to process payments, you're assigned a merchant category code, which is like basically just the line of goods that you are processed or approved to process,
right.
And you can only move those goods.
Right.
And what happens is invariably, the merchant decides to offer a new product, but did not get the express authorization to move that product through its merchant account. And so they're like, we didn't approve you for this.
Yep.
And so boom.
They're going to get
done.
you every time.
You're done.
Yep, 100%. Yeah. Great. That's great advice. Bryce, if you had to choose, if you were given a choice, Bryce, what is your favorite, if you will, reason code? Because it's maybe the easiest to fight, or for another reason, it's your favorite to go up against. What reason code is that?
Well, some of the codes are easy to understand. Some of the codes, pardon my language, but just don't mean shit. I mean, it's just like, okay, so like violation of standards,
right?
That's like a catch-all, and you can never get a straight explanation of exactly what it is that you've done that violates the card brand standards. So that in reality is actually a good one for us because we can work with that.
There's a lot of wiggle room there.
Yeah. Or illegal transactions. That can mean anything. It's like, what makes this illegal? And quite often, it doesn't even involve the law at all.
It doesn't at all.
So I'm just like, why is this illegal? But we can go into that one as well. But yeah, the nebulous ones, excessive fraud, that's kind of a nebulous one.
Right.
The one that kills us almost every time, and I made this point a lot, is the excessive chargebacks. I mean, that is one that every merchant needs to really make sure that they're handling and keeping in contact with the processor about.
That's the one you hate to see.
That's the one I hate to see because unlike all the other ones, it's just the numbers. It's just, the numbers don't lie.
It's cut and dry.
Yeah, and you had mentioned favorites, so let's just talk about my all-time favorite is the identity theft, which we see like way more than I would like. But
yes.
I will say that our whole goal. I don't know that there's a whole lot of other attorneys out there doing these match litigations. Quite honestly, because I still don't think that it's on a lot of people's radar. I meet people like weekly that have absolutely no idea that the match list existed,
right,
or how to get on it. They don't know how they got on it because they'll come at me and be like, well, they didn't even notify me that I was going to be on the match list. And I'm like, well, look at your CFA. There's no notice requirement, and they're quite honestly, they're just cowards. They know what's going to happen if they call you up or write you and say, hey, you're getting matched. So they would rather just stay silent, put it in motion,
you deal with it,
and then wait for you to find out.
Yep. And
then you'll call them, and they won't take your call. So it's just like, well, anyway, back to the identity theft. The whole goal of the match litigation, which is, you'll probably think that I'm kind of full of shit on this, but we want to drive policy change because this is the match list is an antiquated policy with antiquated rules, and this is not a one-size-fits-all, situation.
It's a broken system, 100%.
And the identity theft is, and this one is also difficult for people to understand because I was slow to the roll on this one as well, is that you haven't done anything wrong. Somebody has taken your data and attempted to apply for a merchant account with your personal data. That data is now tainted. So even though you and I both know that the chances of that data being reused or restolen is slim to none,
right,
they're still going to throw that data on match.
Let's talk about wins. What do wins look like in an identity theft situation?
Well, and thank you. The identity theft is not just somebody stole your data. It's that they suspect somebody stealing your data. So it's not like they're 100% digging their heels in on the identity theft. Like, for instance, if you confirm that you were actually the one who tried to apply, then they'll take you off the match. But what I mean by that is, like, first off, don't ignore a bank's inquiry at your peril. Like if I had a client where they were like, hey, we think there may be a violation occurring, but so just investigate. And what we learned is that they just didn't respond. They didn't provide any of the investigative documents that they were asked to provide. So they got matched for identity theft. Right. Or like this one happens all the time. You go into QuickBooks to apply with Intuit. To get QuickBooks, you, for whatever reason, stop the application process and don't provide the documents that they're requesting. They will think that that's identity theft because basically they think
gets flagged.
It's a fraudster who got cold feet or couldn't provide the supportive data and disappeared. They'll match you for that too. So if you can prove that you were the one, well, first off, we have to get them to explain to us what the origin of the identity theft violation is, which is itself a struggle because nobody ever knows anything. We got to get past that roadblock first. But if we can show that it was you, it's a slam dunk removal.
Gotcha. So in a scenario where it wasn't, where the merchant actually was the victim of identity theft, their information was used to obtain fraudulent processing. Then that information
to attempt. Yeah, they never get it. They never get it through.
And was then matched because of that. What about that merchant? Does that merchant have an opportunity to get off the match list?
Probably not. No, probably not. So I mean, but there again are workarounds. You can change, try to get the application, the data on the application as far away from the original application as possible. Get somebody you trust to apply for the merchant account. Or what we always do is we provide legal opinions to prospective processors for our clients to use to basically explain to them that you just need to determine that this person is who they say they are. You don't need to deny them. Just make sure that you have all the data, that you are satisfied that you're dealing with the actual person. Right. Now, I don't understand why, like if a bank hits you for identity theft, and then they hear from MasterCard, hey, you just need to make sure you got the right person, why they can't just resume payment processing with them. But that's just kind of the world we live in right now.
Right, 100%.
And maybe that'll change because, the change in MasterCard's bottom line with regards to identity theft has changed over time. So maybe that word will get out of it.
Hopefully. For people listening right now, I want them to hear at present still how unjust the system is. These are merchants who have been victimized once because they were victims of identity theft, no fault of their own, and then they're being victimized a second time by being on a 5-year prohibition list from processing.
Yeah, you didn't do anything, but we're going to punish you anyway.
And these are people trying to run a business to support their family.
Yeah.
This is the world we live in. This is, unfortunately, the stuff, which is why Bryce was saying, we want policy change. This has to change over time. I say all the time, Bryce, this is killing small businesses in America.
Absolutely.
It's wild. Haven't talked about fraud, which we're seeing more. Now, I know identity theft is a subset of fraud, but fraud is one of the reason codes as well. And that's a very broad category. It's one, like you said, it's kind of a catch-all.
Yeah.
Can you talk to us a little bit, Bryce, about fraud and what do we do in those situations?
Well, the rules say that it's like, because, the excessive chargebacks, it's 1%. Excessive fraud is excessive chargebacks are 1%, just MasterCard. Excessive fraud, the way I'm interpreting it, is that it's 9% across the board and in excess of $5,000, which is really easy threshold to overcome. But my issue with excessive fraud, and where I think it differs from excessive chargebacks, is that it's kind of more of a judgment call by the processor and the bank. And so I don't see. It has to be like really egregious, I think, for them to do it, because you got to remember, these banks and processors, they've invested, and don't think I'm trying to apologize for them, but they've invested significant time and money in getting you onboarded, and they want your fees. I mean, we, like with the peptide industry that we discussed in an earlier podcast, I mean, that industry is getting just wiped off the board, like en masse. And these banks and processors have invested a lot of time. These are lucrative merchants. They want your fees. They don't want to get it to shut down. But so this has created a situation where you can reason with them. And I think that you're going to get, and this is sad to say, but you're going to get the amount of justice that you can afford. And if you're a high dollar roller for these processors and banks, they're going to drag their feet.
You're going to get a little bit special treatment.
The money's too good to
100%. I spoke to a merchant just yesterday, Bryce. They're doing something like $15 million a year in processing. Yeah. They were dealing with Stripe. Yeah. Even Stripe was making phone calls to them, trying to talk with them because they want those fees. That's exactly right, Bryce. I got a question for you, Bryce. We talked about these reason codes, and I hope this is very helpful for the listeners. Without giving away your secret sauce and without giving away anything, proprietary to what we do, because Bryce, let's face it, I'll just say it for you. You are an expert in this field, and you are one of the very few attorneys who does this work to this, extent, day in, day out, and has your level of experience in this. Who are the banks that you actually think you like working with, or processors that you have a good working relationship with? For example, where you say, maybe you see it's, I don't know, Amex or somebody, and you're like, hey, that's good. I know we're going to get a fair shake, versus, oh no, it's this entity. We've got almost no chance at all.
Well, I'm not going to give away the ones that I like, because, this line of work is really all about the context.
Yeah, it's relationships.
and the relationships. And over time, you can kind of shape the way that they're looking at this. Like some banks that are really coming around, but they're coming around because their attorneys are bringing them around.
Yep.
Is just my argument of the fact that, like, why do we have to do this song and dance every time? Like why do we have to spend an enormous amount of money on both sides just getting them to explain why they did what they did? If you really believe in what you did, then why won't you stand behind it? And so I've had success in getting some attorneys at some of these banks to realize, why does the bank have to go out and get litigation counsel and hire a whole nother attorney, whole nother law firm to basically just answer the question? Like why can't you have a dog? And that's where I've learned over time that some of these banks, like, they're not even allowed to talk to us. So it really does take a complaint to get things going. So I'm not really ready to give away my secret sauce.
Good.
But the ones that I just roll my eyes is Elevon. Elevon every day and twice on Sundays. It's just like I've been able to show them that they were mistaken about a match placement, that it wasn't even like them. That it was a completely different website, and they just shrugged their shoulders.
Yeah, blows me away.
Like daring me to sue them, and a lot of merchants just can't take that stuff.
Right.
But when I see Elevon, I know we're going to be in for a fight.
It's an uphill battle.
Now I will say that there have been some instances where they have agreed to help the merchant to find alternate processing because they believe that it also is not a fair placement. But by and large, they're just completely just horrible to deal with.
Yeah, understood. So, Bryce, as we come towards the end of this conversation, one, I want to thank you for discussing these reason codes, match list reason codes with us. Very informative and helpful. I'm glad you're not giving away the secret sauce. The reality is, I've seen it with my own eyes. You've been doing this for years now. You do have a lot of great relationships with a lot of these entities. And, you're not buddy-buddy with them, but you're able to get things done because we win match matters. It's not an uncommon occurrence for us to win a match case. And a lot of it's because of these relationships you've discussed, Bryce, which I think is a great thing. On that point, you've brought it up a couple times now, filing a complaint, filing a lawsuit. Can you talk to us briefly about the difference between going to arbitration on a matchless matter because of the arbitration clause versus filing a complaint? What are you looking at, Bryce, in a matchless situation to decide, should we file a notice of arbitration, or should we just file a lawsuit, or should we waive the complaint in the attorney's face? How do you approach that calculus, Bryce?
Well, okay, first off, I don't even broach the topic of a complaint, and I either with the client or the target, unless I'm 100% certain that we're going to go through with it. Because if I get a reputation for going around town and saying, I'm going to sue you, and then no lawsuit ever comes, like, I might as well just hang it up and go like do landscaping or something. I mean, because I'll have absolutely no credibility. So you have to do that. But I try to avoid arbitration at all costs, but it's becoming just absolutely impossible. Let's hire an attorney and give him ultimate power over everything, and you can't appeal it, and it'll be all confidential. Like, what could possibly go wrong with that? It's just like, why? And you're dealing with it's kind of a dirty little secret, but you're dealing with an arbitrator or arbitration system where they're incentivized to drag it out as long as they can,
because they're making money.
And it may not be something that they are intentionally doing, but God damn it sure seems like it sometimes. It's just like, how my argument is clear, but you're going to kick the can down the road because you guys aren't done on charges.
Right.
I like to start in court. It's a public forum. It's accessible. It's public knowledge. It kind of puts them on the spot. It allows me to talk about it in podcasts like this. So, and then sometimes the bank they don't actually pull the trigger on their own arbitration clause. So why would I make that assumption?
right.
So and the deadlines and the rules in the court system are strictly followed.
Yeah.
Arbitration is kind of like a wink and a nod, so it's like arbitration has its place. I think at the end of the day, it might be cheaper, although again, you have to account for the fact that they're going to try to drag it out as long as they can. But yeah, I would prefer to be in court
Gotcha.
every time. But what we will do, and which I've had some success in, is that we just send them a draft of the complaint and be like, this is real. We're coming. We're not going away. I've written enough letters. Respond to me within a week, or we file this on Monday. And invariably that gets us.
Yeah. Great. So, Bryce, thank you so much. Bryce Vandemore, Senior Associate Attorney here at Global Legal Law Firm. He oversees, Bryce isn't doing this stuff on his own. He has a team that works on these match matters, including reserve fund issues, every single day in-house. If you are on the match list, please contact, if not Global Legal Law Firm, contact a law firm. It is virtually impossible to get off the match list without legal assistance. Our firm does this work day in, day out. We have a team dedicated to this type of work. So please give us a call. Go to our website. There's other podcast episodes. You can hear Bryce going on about this.
One caveat.
Please.
One caveat. And I'm not talking about anybody specifically, but I spent decades in like the insurance defense line of work and some plaintiffs work as well. Payment processing is really its own animal, and it's just a very niche industry with very obscure regulations that are ironclad enforced. And so I think that the tendency for a lot of civil litigation attorneys is like, oh, this is just another business transaction. This is another contract action.
Right.
I can handle this. Try to determine with your attorney at the outset, or your prospective attorney, do you have any payment processing experience? Because I see it all the time.
All the time.
Like attorneys are in there and they're in,
and they're probably good attorneys.
And they are good attorneys, but they're in way over their head because they just don't even understand the
intricacies of the payment system
of dealing with MasterCard and the card brand rules and what that entails. And I'm still learning stuff. Like 5 years later, I'm still learning stuff every day.
Thank you for listening to this episode of the Payments Experts Podcast, a podcast of Global Legal Law Firm. Visit us online today at globallegallawfirm.com.